Hey guys, welcome back. Advocates with Justice Foreclosure Defense Paralegal Service. We have the tools, you do the work. Tonight we're going to talk about how to respond or reply to the opposing party's motion to dismiss. We're also going to talk a little bit about responding to complaint. We never answer to the complaint, we respond. We're going to talk about responding to the complaint. First, we're going to look at their conventional system and talk a little bit about that, and hopefully that'll help you understand what we're going to be doing a little bit later on. But before we get to all of that, I want to take a minute and remind you guys to please make sure you click on those annoying ads that pop up so I can get paid. When I get paid, you guys get a better deal. Also want to make sure that you guys subscribe to my channel. That lets YouTube know that I got it going on. Click the like button. That like button lets the algorithms know that I'm bringing value to the table. Please leave a comment. Please leave a comment. That lets everybody that looks at my YouTube channel see that you guys find value in what I'm doing. Last but not least, please make share my videos on your social media platforms so other people will see that they have a chance, especially if you live in California. Because the attorneys in California are a little grumpy with me from my property tax lawsuit package, and they've contacted Facebook and had Facebook block me from advertising on their platform. So they haven't figured out there's more than one way to get shit done. So if you guys could share my stuff, I really appreciate it. And make sure you ring the bell so you get notified when class starts. So let's get rolling. First, we're going to look at the conventional system, and I'm going to show you kind of how it's set up. We're going to talk about that for a minute as soon as I figure out how to do screen share. And there we go. First off, we're going to talk about just a little bit about how to answer the complaint. And I found this online. Well, before we get to that, let's go to the first one here. I had a person contact me, that they filed a motion to dismiss. And they were like, well, what do I do? What do I do? How do I respond? And I'm like, well, you need to figure this out. So I'm going to help you guys out a little bit with that. Go to Google and type in, like right here, how to defeat a motion to dismiss. And look what you get. You'll get a whole ton of shit here that you can learn and read from. Then you just pick through this and figure out which one you need till you figure out what's going on with that motion to dismiss and how to respond to it. And if you go back, look at all of these pages down here, all have to do with this subject. And you can find documents that other people made. You can even Google that with your state on the end and pull up motion specific for your state. It's incredible what you can do on Google, but people think you have to go to the law library. You don't have to go to the law library, people. Okay, it's right there in your home at your fingertips. You just go to Google. And when you get good at this, you can learn how to look up anything you need to find on Google. Case law, you can look up the laws that they're supposed to be following that they ain't following. You can look up all kind of stuff on Google. So, and that's why I left this here. I want to show you guys. You can look this stuff up right on Google. Now, what I like to do is look up a document that if I'm going to structure a document, I'll do some research on it. And then I'll save the links for all of the ones that look promising, like I might can use the information from them in a note Word. And then I'll copy and paste stuff in that Word, all the information, the facts. And then when I start building a document, I'll use the information out of that document that I just built to build the new document, because I have all of the facts that I need right here. And then I'll put the facts together over here to build the document that I need. All done right off of Google. You'd be surprised at what you can find. Now, you need to understand that not everything on Google is true. Attorneys post shit on there to mess with people's heads. And when you've been doing this for as long as I have, you can see right through that shit. But you guys will be able to, since you're in my program and you're learning the real deal, what's going down for real. Once you start learning this stuff, it'll be a lot easier for you guys to sift your way through the bullshit that the attorneys put to distract you on Google, and you'll be able to tell what's real and what ain't. So that's important. You need to find out something, Google it. There you go. How to defeat a motion to dismiss. So let's get over here. We'll get back to that here in a minute. Let's get over here to how to answer the complaint. I want you guys to see how they set it up. And when I say they, you'll understand what I mean. The attorneys are the ones that structured the program, that the legal system that we're using. And it's not structured to be fair for us. And that's the fact, Jack. Anybody that ain't figured that out yet is still paying their attorney. Right? Think about it here. You can see the instructions here. They're telling you got 30 days to answer. Read the complaint carefully. If you note that the allegations or the statements in the complaint are set, if you notice they're set in paragraphs and they're numbered consecutively, you should respond to each paragraph in the complaint using the exact number used in the complaint. The plaintiff is the person or the entity who initiates and files the complaint. The name of the complaint appears in the top half. Okay, so that's all pretty excellent. So we're just going to scroll down here a little bit. And it talks about when you must answer the complaint. Depending on your situation, most people have 30 days or 21 days or whatever. And then answering the complaint. Your response to the complaint is called your answer. Now, we never answer. And when we get to the end of this, I'll tell you right now, we never answer, because if you answer to their fraud, you're still going to be standing in a pile of shit when you get to court. Okay, because everything they're doing is fraud. So if you answer to that, I don't, anything you say in response, defending yourself in their lies is not going to help you. And I don't care how much evidence people call evidence. Oh, I have proof that the lender, the servicer, all of that. None of that matters. It does not matter. We don't answer to the complaint. We don't defend ourselves to what they said you did or didn't do. Okay. What you're going to learn how to do in my program is go after them for the fraud that's causing the problem that you have right now. Okay. The misconduct that's causing the problem that you're having right now. That's what you're going to be suing them for. Okay. Instead of trying to answer. And if you read the rules, you can respond with your defenses, particularly challenging a jurisdiction, before you have to give any kind of an answer. And like I said, if you respond the right way, then the answer things off the table, and their hands are full trying to prove jurisdiction and get the shit that you're going to stick in their face out of their face. So we don't answer to the complaint. We respond. And you respond with what you need to trump them and kick their ass with. We're going to teach you how to do that. That's what part of the program. That's what this program is about. We don't do all of this. This is ridiculous. And that's why I'm showing it to you. Be very careful with the statements you make in your answer. These statements can be admissions of fact that could be used against you. You must be truthful in the brief. Oh, so they're saying to be careful what I say, because they're going to use everything that I put in here against me. And I must be careful in the brief to make sure I don't mention nothing in the brief either. Well, let's jump on the ass with jurisdiction. You ain't got to worry about none of this. Then you must agree or admit that you didn't agree. All of that is ridiculous. I mean, it's just totally stupid to me. This is what they want you to do in their conventional program, so they can finish kicking your ass with the answers that you gave them. They'll use those answers that you put in this shit to argue in court that they should have the summary judgment, basically, because they're going to twist up your answers to make it appear that there's nothing in controversy because you're stupid and have no idea what the hell you're talking about. You owe them money, even though they can't prove you that they made you a loan. They can't even provide the original contract that they're saying was the loan. They can't provide an injured party. They can't eat. Yeah, okay. So I could go on with the they can't for a while. They have not proved anything. Having and the document that they file in court is signed by the attorney. It's not signed by the lender or anybody from the lender's organization. So I just want to scroll this down so people can read the nonsense that they want to try to make you do. And you know what? People jump through hoops doing this bullshit all the time. It's crazy. They'll call me, oh, dude, I don't want to hear none of that because we're not going to be using any of that crap in my program. In my program, the only thing that you're going to be using that's connected to their conventional crap is a copy of the document that they use to initiate the foreclosure proceedings against your property. So in a non-judicial foreclosure, you will be using a copy of the lawsuit, petition, the complaint, or whatever attached as an exhibit to the lawsuit that you get from me. And the reason you're doing that is because you're going to add the attorney as an M1 defendant on your lawsuit that you get from me, and the law firm second, and the last servicer. That's it. 3 people. That's it. Not all of those people. Okay, because all that does is just make it complicated for you, give them a whole bunch of legs up. 3 people. That's all you add. And when you add the attorney as an M1 defendant, that's going to cause a problem. That is going to cause a problem for the attorney, and that's why we do that. And the reason why we attach a copy of the petition, or in a non-judicial, it's the notice of default letter. The reason we attach that is because when you go to file your lawsuit or your counterclaim, if you're going to file in the state court process just to mess up their shit, because if you're struggling, you don't have to pay the $400. You can file it in state court, and yeah, you can do that. And when you do that, that's going to cause a problem for the attorney. And you want to make sure that you get this filed and stuck in their face. Now, we're going to scroll down here a little further. And it talks about the wherefore clause. We we use the conclusion, but we can use the wherefore clause. That's really the only thing that's important in their stuff, is what they're asking for. All of the rest of the stuff they put in there is basically designed to get you to lean, so they can, either way you lean, they're going to use it against you. And then here's the instructions for filing the lawsuit. Now, if you're looking for the instructions for filing in your state, you should be specific to make sure that you're looking at something that's from your state, that's for your state, because sometimes that can be a little bit tricky. You can see the conventional program is structured by the attorneys, and they hold your hand with their document and walk your ass right down the path so they can shoot you while you're walking down the path. Yep. As you can see, that's what this is for. So the response or reply to the opposing party's pleadings in your answer or the opposing party's documents filed in court. We're going to talk about that. A response or reply to the opposing party's pleadings is your answer to the opposing party's documents filed in court. I don't really like to use the word answer. I like to just use a reply or respond or whatever. And basically, the response is the initial answering to a motion. So your response to their motion, and then they get a chance to reply last. Now, the reply part of this is very interesting because a lot of attorneys throw people under the bus after they've been paid, because the people have no idea that they have to reply. Right. So you file a motion, the other side responds, and then you have to reply last if you initiate the motion. And a lot of people don't realize that has to take place. And if your attorney understands that you don't know, then they'll just won't reply, and then you lose. Of course, they blame it on the judge. Well, I don't know, what, your ass under the bus. That's what happened. Make it plain and clear. And that reply is how a lot of attorneys violate state citizens. So you can think about that if that's ever happened to you. The attorney will not reply if they know you have no idea that they have to. Then that makes your job easier. A motion, response, and replies are connected steps in the series of pleadings with the court. A response will address the motion and provide a party's position on the points raised in the motion. This can include a rebuttal to issues of fact or law raised in the motion. A reply will address the points raised in the response and provide a party's position on the points in the response. So this can include a rebuttal on the issues of facts of law raised in the response. A reply should only address points raised in the response. Now, that's part of their thinking. I don't agree with that. I think your reply could have in it whatever you need to smash them in the face. That's how I roll with that. I do not let these little rules limit and restrict me, because here's the deal. All of these rules they're expecting you to follow, they're not following none of them. And if you ain't figured that out by now, you should go home and pack your shit. I'm telling you. The attorneys expect you to jump through these hoops and do all this shit, and they're not doing any of it. The reply is not a place to argue points made in the original motion or to raise new issues. I think the reply should be used for whatever you need to use it for to be able to stay in your damn house. That's the way we roll. The main reason attorneys move to dismiss is for failure to state a claim for relief under Rule 12B of Federal Rules of Civil Procedure. And I structured a video to help you guys learn how to do this, because if you bought the lawsuit package, you're going to have to do a little work on stating a claim for relief and make it specific to your situation. You'll have to follow the video, and you can go to my YouTube channel, and at the top of the channel in the search bar, type in how to state a claim for relief, and it'll pull up the couple of videos that I have. You can watch those videos, and it walks you through what you need to do to state a claim for relief. It's very easy. It's very easy. So if you're freaking out, go breathe in a paper bag before you pull it up and look at it. Okay, it's very easy to do. Once you see what the rules are and what you have to do, you'll be saying, damn, this is easy. Attorneys have it easy. They just make it look complicated so it can scare people off and make people think they have no hope. They like to do shit to steal your hope. They're hope stealers, and we ain't letting them steal our hope up in here, because we're keeping our hope, because we are hope people that like to, okay, sorry, got carried away. Attached to the motion will be the memorandum of law, which gives the defendant's legal arguments for dismissing your lawsuit. The opposition is a memorandum of law that responds to the defendant's argument. This motion to dismiss cannot be heard until jurisdiction has been proven on the record. So that's one of the things that you're going to have up your sleeve. Once you challenge jurisdiction, everything else has to come to a stop until they prove jurisdiction on the record. So if I was responding to their motion to dismiss, the first thing I would say was this is inappropriate, because they had not responded to the motion for challenge. Their jurisdictional challenge was an affidavit. So it's inappropriate for them to file any other documents and ask the court for anything until they have filed jurisdiction, have proved jurisdiction on the record. So I want to have that first, and then I go ahead and respond to their trash, because they can never respond or reply. They can never respond to the merits of what we're sticking in their face. They never do. They blah boo ha all the way around, and in the end, it's really easy to respond to them because they never address anything on the merits of the document that you sent them. So that makes it easy. They didn't address anything on the merits. Okay, you want to put a little more than that in there. One thing you will have going for you is that in considering the defendant's motion to dismiss, the judge must assume that every fact that you state in your complaint is true. The judge must then ask, if those facts are true, is it plausible that the defendant violated your rights? If any combination of the facts stated in your complaint might qualify you for a form of court action under Section 1983, then the judge is legally required to deny the attorney's motion to dismiss your complaint. But that's not how it goes all the time because of the corruption. In the motion to dismiss, the defendant will point out some defects in your complaint and ask the judge to dismiss the action. So they'll point out pretty much most of the defects, Except the one defect they don't point out is when you don't make a specification as to the mindset of the perpetrators. That's what we're gonna call them, perpetrators. And if you follow the video that I put together on how to state a claim for relief, you'll understand exactly what I'm talking about. They never mention that in it. They mention everything else that you stated wrong, but there's one thing they don't mention that you did wrong because they don't want to help you with that. But most of the stuff that they'll have to mention is a problem with your lawsuit in there. Now, they could mention everything in there as BS, which most of the time it is. A lot of times they'll say you didn't state a claim for relief, and a lot of people don't study that before they do that. And fact of the matter is, you don't have to do that if you have enough factual information in your document, which mine does, and that's why I never worried about that in the first place. And I don't like to follow their shit, but they're still trying to use that. If that's all they got, well, we're just going to crush that and move on down the road. That's what we're doing right now. To oppose dismissal, you should research the draft motion in opposition, the motion that they filed against you, and pick it. Pick it apart. But make sure that if they haven't responded to your jurisdictional challenge with an affidavit, you get that up front stated. Okay. That lets them know that you're still on that jurisdiction and they need to do that, but you're going to answer to their bullshit anyway, just because you can. File your motion opposing what they're doing, and you state in there that they haven't responded to your jurisdictional challenge with an affidavit by counter affidavit. They have no standing to be asking the court for anything, because the court cannot take any action until jurisdiction has been proved on the record. When you get the motion from the opposing party to dismiss, you need to look and see why they're dismissing it. If they're dismissing it because of failure to state a claim for relief, then you need to go to my YouTube video, to my YouTube channel, and search out the video stating how to state a claim for relief, and then you need to amend your motion. You get one free amendment. This helps you guys out tonight. I think the biggest tip that I'm leaving you with here tonight is Google. Use it. If you got to respond to a motion dismiss, do your research on Google. Look it up. See what you got to prove, what they're going to say. If they file a summary judgment against you, look it up. The rules for summary judgment. You can look up other people. There's so much you can do yourself with the internet. You don't have to go to the law library or worry about hiring an attorney. You just need to prioritize your time so that you're using enough time, as much time as you need to understand this stuff. Because if you don't understand it, you're going to have a hard time when it's time to face the devil, the two devils trying to steal your property. You're going to have a hard time coming up with the words that you need to get on the record to sue them with. Okay, that's what we're doing. We want to build your record to sue the judge with when the judge helps the attorney get a pass. That's about all I have for you guys tonight. I will see you in the next video. This is going to be a series of videos because there's a lot of other things that I want to talk about when it comes to responding to their stuff and blocking their motion to dismiss. But we're just going to start out with the basics today. So this is going to be number one, and we will be back with some more stuff. So thank you guys for the privilege of your time, and I'll see you in the next video. And don't forget to subscribe, click that button, and ring the bell. And make sure you watch those wonderful ads. They're not annoying anymore. They're wonderful.